Morning.
Good morning, Mr. Commissioner, members. Mr. Commissioner, we are ready to start. And luckily this morning we don't have the logistical problems of yesterday, and we will try and make up time. We have a busy schedule for this morning. We plan to bring 5 witnesses to the Commission today. Injury time and extra time permitting. But we're ready to start, and my colleague Advocate Gue is ready to start with Mr. Raja.
Thank you. Yes, Ms. Gue.
Good morning, Commissioner, members. Mr. Raja is ready to proceed with MST. May I please sit?
Yes.
Thank you.
Let me sit here. Mr. Raja, I think it's a new day, so let's take the oath afresh. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help me God?
So help me God.
Thank you very much. Yes.
Good morning. Commissioner, before I start with the MST transaction, I just thought if you would allow me to make a correction to one of the answers I had given to Ms. Marcus on one of her questions yesterday on SNS Refinery, if I may. Ms. Marcus asked me whether on the EcoBank, whether the loan or the LC was being serviced. And I answered yes. I'd just like to correct that it was serviced on the first tranche. The second tranche, as I understand, has been partially serviced but not fully settled. So I just wanted to clarify that.
Good morning. Morning, Mr. Raja. Yeah, just to follow up on the SNS issue. The one question which I was not clear about was on the equity contribution of the company. You mentioned that there was $22 million that Mr. Rasool contributed, and you said the $18 million was for the PIC, meaning, did you mean that there was a total of 40 million of equity, or did you mean that 28 million that the PIC used was used to pay out Mr. the man, Mr. Rasool?
Okay,
yeah. Yes, if you can clarify that, because it's one thing which I'm still not sure there. Yeah.
Okay, the issued share capital of the company would be $40 million. Subsequent to that, there would have been the $40 million would have been an equity subscription. So that subsequent to that, when there was an additional $10 million, that was just a purchase and sale between the shareholders. So it did not alter the share capital of the company. The share capital of the company still remains $40 million.
I see. So in terms of the total project cost, there was that 22, which was in the balance sheet. It was never touched. He contributed that. And then there was the 18 million that the PIC contributed, which was part of the project cost. It was not touched. The only money that he got was the 10 million, which came to buy that 25% stake. Okay,
yes, that would have been the purchase of shares. But right at the outset, as I mentioned, Mr. Rasool had funded the projects through shareholder loans. So when PIC money came in, it had come into the company, would have paid some of that loans, and the balance converted into share capital. But in the end analysis of it, of the first sequence of the transactions, it would have been a $40 million share capital, and that would have remained even up till today. And the 10 million is just a purchase direct between Mr. Rasool and PIC.
And the PIC,
yeah.
Okay, all right, yeah.
Mr. Raja, am I correct that the overview of impact investing division and roles and responsibility remains the same as you outlined yesterday?
That is true, except for the part of where I was senior fund principal, I'm now executive head of impact investing, but in terms of roles and responsibilities and structure of the division, it remains the same.
In that case, I'm going to ask you to start at paragraph 7 of your statement.
Okay, so if I started paragraph 7, which deals with the origination of the MST transaction. Sometime in June 2015, PIC's Chief Financial Officer, Ms. Matsepo Mora, mentioned to me that someone had inquired about whether we could consider providing funding for mobile buses to be used for inter alia health and education purposes. I indicated that on the face of it, the nature of the project falls within the investment mandate. However, we would require additional information. She indicated she would refer them to the impact investing team, then called developmental investments, and we should see whether it is viable or not.
Sorry, Mr. Roger, just on that, did you subsequently find out who that person was that who had approached them?
Yes, it was the client, Mr. Watkins.
Mr. Watkins, thank you.
On Thursday, the 2nd of July 2015, the CFO forwarded documentation which mobile specialized technology, which I'll refer to as MST, sent to her. On 6th of July 2015, I furnished I forwarded the same email to Ms. Sepati Moichela, an associate principal in the social infrastructure team of the impact investing division.
Just to check something there quickly, is that when you get a transaction, how do you decide where it goes? I mean, whether it's private equity or your division and the other divisions?
Okay, through you, Commissioner. What would happen if a transaction came through to me? I would understand what the criteria is for private equity as well as for other divisions within PIC. If it falls within those divisions, I would send that through to the head of that division. Now, in this particular case, when the transaction was described to me, I had already known that it fits within my division, hence I requested Ms. Moore to send through the proposal through to me. When it comes to me, within my team, I would have different fund principles. I'll have one that would cover energy, one that would cover social infrastructure, that is education, health, and affordable housing. I would have one that covers SMEs, one that covers what we refer to as priority sector, but that covers a broad range of sectors where there's high job creation. So, and then I'll have a person who will deal with economic infrastructure. So when the proposal comes to me, I'll look at the nature of it and I'll forward it to the appropriate person.
So meaning that, okay, the main question is that what is the difference between your division, say, and private equity and SIPs? I mean, what would be the key differences there?
Okay, the key difference, I'm dealing with it predominantly. What the difference is on private equity, it will tend to be your BEE type transactions where there's transfer of ownership from one to another. So it has although it could have impact on the company, it does not have impact on the company's balance sheet. It is just a share transfer transaction between two shareholders. Of course, you could get situations where there is a BE transaction with a subscription of shares where money flows into the company. There's a fresh issue of shares and the proceeds flow into the company. On my side, on the impact investing side, we're dealing here predominantly with a situation where you are investing in startups or in expansions. Now, how we've tried to distinguish between whether it goes into private equity or impact investing is that we say if the majority of the capital required goes into the company to enhance the productive capacity of that company, that would fall on the impact investing side. If the majority of the funds flows into the hands of another shareholder, that would fall in the private equity side. So that would be the distinction.
Yeah, that's clear. Thanks.
Through you, Commissioner, if I can proceed to the overview of MST, which is paragraph 9. MST manufactures and kits buses from corporate social responsibility funds or from government departments and public entities to be used to offer social benefit to society. MST offers a complete service solution incorporating vehicle custom design, manufacturing, operations and maintenance, including the staffing of the mobile, school, healthcare and educational bus units. MST has evolved over time while continually refining its solutions to offer a one-stop shop for all its clients' mobile needs. As a result, MST Group established specialized subsidiaries or divisions to focus on core functions to ensure that comprehensive solutions are on offer. MST Mobile Healthcare and MST Education buses are used to provide healthcare services and education services to children at school. MST provides preventative healthcare which allows for early detection and correction of simple health problems before they become disabling matters. The mobile health buses are fully customized and consist of primary healthcare consultation room, an optometry room, and a dental consultation room. Education buses provide children with exposure to technology and offer career guidance to spearhead the learner's growth path.
Sorry, Mr. Raja, on paragraphs 9 and 10, as you've outlined what MST does, is that knowledge you have of what they do from your due diligence, or is it what they say they do?
That is knowledge from what we know they do during due diligence. Of course, we have also established during due diligence they do other things as well, such as on the HIV testing, as well as registration of contractors or small contractors with NHBRC for CIDB grading as well.
And in that, in your due diligence, how many buses did they actually have in operation doing all of this? Given that the request was for building more buses,
yes.
So one would assume if they need to build more buses, they've got some in operation, given what you've said here. Just to get an idea of the scale of what is the current, at this point in time, what was the current functioning and what was the add-on that was required from the PIC?
Through your Commissioner, I think it's in somewhere around 25, if I'm not mistaken. We can get the exact numbers. And then the funding for the PIC was for an additional 7 buses.
I think let's get the exact number that were operational at this point in time, so that one could, because it's a national operation, it's not although it's based in Western Cape, it's a national operation, so we know how many that is. And when you do come to that point, please just indicate why the initial request and the documentation was for 14 buses, but the actual approval was for 7. How did it go from 14 to 7? And then obviously we would want to know how many actually were made.
Okay.
I'm tempted to ask where this is happening.
Western
Is it only in the Western Cape? Because I wish I could see some in the Eastern Cape.
Chair, I understand it's beyond the Eastern Cape. I think it's also in Mpumalanga, but I think a lot of the detail, I'm sure Ms. Constance will come in, will actually even provide in terms of the number of buses as well as explaining the 14 and the 7 as well.
Just want to check their business. Do they manufacture the buses and then hand them over to some people to operate them, or they manufacture and they operate those services, you know?
Through your Commissioner, both. So it's one way you'd manufacture and you would sell it off completely. The other one would be you'd manufacture and you'll operate it as well. So it's the both services. Commissioner, if I can move to paragraph 11. In June 2015, MST had applied for a loan of 45 million. Following discussions between PIC's investment team and MST, a scoping report was tabled on 16 July for consideration to the Portfolio Management Committee. The Portfolio Management Committee approved for the transaction to proceed to due diligence. Upon completion of the due diligence, the investment team presented the investment to PMC on 23rd November 2015, where PMC approved a term loan of 30 million plus 25% equity at a nominal amount of 25 rand.
Just to check, on paragraph 9, you mentioned that they used to operate by getting money from CSI funds, government funds. So were they trying to be a profit-making company, or were they non-profit before?
Through you, Commissioner, it has always been a profit-making company. When the investment team informed MST of the conditions of approval by PMC, MST was not willing to offer equity to PIC unless it was offered based on a company value of 103 million rand. This amount is, to the best of my recollection, but I remember it being 103 million rand. When the investment team mentioned this value to me, I refused because it meant PIC must pay for the value created as a result of funds provided by the PIC. So there's an established principle in PIC that where we're putting in money into a company, and because valuations are based on a forward-looking picture, if we're putting in the money and that is creating the profits, we cannot base a value on that. The value must be based on excluding our funds, and hence I had refused for the transaction to be done on the basis of 103 million rand valuation. At a point in time, I was traveling to Cape Town, and the client became aware of my travel arrangements and requested a meeting with me whilst I was in Cape Town. Prior to my return to Johannesburg, I met with the client at Cape Town International Airport. This was the first time I had ever met any representative from MST, and that's largely because I do not get involved in the due diligence process.
Sorry, do you know, do you know why the client contacted you specifically, and why didn't they contact the team rather?
I would imagine that because it dealt with an issue of the critical part of the terms of the funding, they would have thought that I would probably be in a more senior position to maybe make a determination as to whether I'd be able to agree to another structure. And I'm sure maybe the team had mentioned to them that it was I who had refused the valuation of the 103 million. So at the meeting, I explained to the client that because the client didn't want to give us shareholding unless we paid at market price. So I explained to the client that PIC receives a mandate from its clients. The mandate stipulates the return expectations, and therefore a conventional term loan would not enable PIC to achieve its return. The client agreed that we could explore alternative structures so as to meet mandate requirements. On 8th of June 2016, the PMC granted approval for a revised proposal comprising a debt facility of 21 million rand, bearing commercial rates plus a 5% profit share. I'd just like to add at this point in time, you'll notice the amount had come down from 30 million to 21 million, and that was at the client's request. Because in the meantime, the client had also been approaching Mercedes-Benz for finance. Following the approval, legal agreements were signed, and after fulfillment of the suspensive conditions, funds were disbursed on 6 July 2017 into the bank account of MST. With regards to my involvement in the MST deal, with regards to this particular transaction, I had no direct involvement in the transaction other than ascertaining the nature of the transaction did indeed fit the PIC mandate. Upon receipt of email and attachment sent to me on, if I can correct that, it's 2nd of July 2015 by Ms. Matsepo Mora, I had forwarded the same email 2 business days later to Ms. Sepati Matjila, an associate principal in the Impact Investing Division. From this point onwards, the investment team ran with the project, and at each point in the investment process where submissions need to be made to the relevant PIC committees, I would review the document compiled by the investment team and sign these for submission. The conditions precedent is stated in page 81 of the term sheet.
Question? Do you know how Ms. More got in contact with the MST, the company, the initial contacts and all that?
No, I don't. But all I know is that she had told me that she had met some people who were looking at funding for this kind of initiative, and she had described it to me, and based on the description, I felt it met the mandate, and all I said is get them to send through the proposal to me. The conditions precedent is stated on page 81 of the term loan facility agreement concluded between MST and PIC, and this was done on behalf of the Unemployment Insurance Fund. The following are paraphrasing of the conditions precedent: providing certified founding documents, providing certified copy of shareholders register, providing relevant corporate authorization and approvals to give effect to the loan, including provision of specimen signatures, confirmation of borrowing authority, absence of defaults, and various representations and warranties. All other related agreements are correct, complete, and accurate, and in full force and effect, and there is full compliance with financial covenants. No material adverse change has occurred, financial or otherwise. Various documents evidencing pledge, cession, guarantees, and subordination of debts in favor of PIC were to be duly executed and become unconditional and in full force and effect. Certified copy of the related annual financial statements, certified copy of the consolidated annual budget, provision of a legal opinion regarding incorporation capacity and due authorization by the borrower. Lending approvals must have become unconditional. Auditors confirming liabilities, shareholder loans, percentages, and trading history. The provision of a 5-year business plan, and providing tax clearance certificates. These conditions were fulfilled.
Sorry, can I ask you, did MST provide audited financial statements certified?
Look, through your Commissioner, yes, MST had provided audited financial statements as at 30th of June 2015. But I would come later to why I feel that perhaps prior to disbursement we should have had 30th June 2016. These conditions were fulfilled prior to disbursement taking place. It is worth pointing out the following. The special notarial bond is incapable of being registered until the buses have been constructed as specific identifiable information about the assets must be in place before a special notarial bond is registered. Technically, the provision of 30th June 2015 audited financial statements would discharge the condition of providing annual financial statements. However, in retrospect, PIC should have demanded the provision of 30th June 2016 audited financial statements prior to disbursement. I'd like to mention at this point that what the team had done in the absence of because those financial statements as at 30th June 2016 was not in place. The team had obtained the management accounts and interrogated the numbers to test for their integrity, but there was no audited financial statements at 30th June 2016.
Have those financial statements subsequently been provided, and obviously in the subsequent years been provided to PIC?
Through you, Commissioner, that has been a problem in obtaining these financial statements. They did, however, send through some financial statements for 2017 in January of this year. However, we have to point out that whilst it may meet the requirements of the Companies Act, in terms of in the Companies Act, there's provisions depending on the public interest score. You could have financial statements that are independently reviewed. You could have financial statements that are audited. What seemingly is provided is what is independently reviewed. Whilst it might meet with the requirements of the Companies Act, it does not meet the requirements of the PIC legal agreements, which is to provide audited financial statement regardless of what your public interest score is.
Yeah, just a couple of questions on this company. You were giving them a loan of 21 million. Two questions. Was this the normal size of a typical transaction within your division? And in terms of growth, I mean, was this company sort of promising quite some growth?
Through you, Commissioner, in terms of size, we would typically do transactions above 50 million rand, but what we do is that we haven't had it cast in stone. Usually, sometimes when we do go to the committees implore on us to, where we find transactions that have good social impact, we should look at transactions of smaller amounts. But on my division, I think the smallest transaction we had ever done was a transaction for 5 million rand. I think this would have been the next. Then there was one for 20 million, and I think this is the third smallest transaction we had done in the unit. Mr. Lidiga, if you can just repeat your second question.
Just in terms of growth of this business, I mean, was that quite promising or what? Yeah.
I think on our side, we looked at it from the point of view, if we take how BEE has evolved over time, and if we look at the compliance with it, and that you'd find that you can see clearly there's more and more commitment to BEE. So I think in terms of how much of money was going to flow from whether it was CSI budgets or enterprise development budgets, we saw that as growth. But I think importantly, what we looked at was the benefit that this was offering to particularly youth in the country, which was a strong reason why even later we even considered providing funding from our corporate side, not from client funds, in terms of the CSI, because we thought it was doing good to society.
And besides the money you put in this company, what is your typical check size? What is your typical check size, average check size?
That would be difficult for me to, but we can provide that information. We can look at the transaction and we'll give you maybe the average, and we'll give it to you in buckets. We can provide that to the Commission.
Yes, please. Yes, please.
Sorry, Mr. Raja. I just wanted to find out, was the forecasted financials a realistic forecast of the projected revenue growth? And can you also provide us with same, if there were?
Through your Commissioner, at the time we thought it's Well, what has since happened, well, the client is making allegations that as a result of all the negative publicity surrounded the MST transaction, that the PIC is the responsible party for the decline in the revenues, which we refute. But we will provide the historical financial statements. The present status of the investment, as the Commission may be aware, this investment has received widespread adverse media coverage over the past 18 months. I think you'd see a lot of the stories relating to the CEO and the girlfriend story, but I think that was the publicity that was out there. MST is in default in terms...
Yeah. Just to be clear, so the girlfriend story is about the 5 million which was in the CSI fund, and this 21 million is a separate matter because this is the company. Is that correct?
Factually speaking, the involvement of Ms. Pretty Low was on the 5 million. But if you take media coverage focused mainly on the 21 million. That was what's in the media. So if you look at media articles, it's talking about the 21 million rather than the 5 million. But factually speaking, the story should have been on 5 million, not on the 21 million.
Did Ms. Low participate in the raising of the capital on the 21 million?
Through you, Commissioner. May I proceed, Commissioner? Through you, Commissioner, no, in fact, when the 21 million rand transaction was done, we didn't even know of the existence of Ms. Pretty Low. That we had met with her, I think it was in somewhere around in October 2017, if I'm not mistaken.
So no one got transaction fees in this one?
Not to my knowledge, Commissioner. Maybe the amount was too small.
I'm still interested in this thing. MST, is it only operational in the Western Cape or is it a national initiative?
It's not national, but it is in a few provinces. It's not, not in a Western Cape, but it is in a few provinces that the vehicle travels.
Yeah, I'm just worried about, I see you say it gets funding from CSR funds or from government.
That's
why I'm asking.
From my understanding, most of it is from government or CSI or public entities. Those would be the target market. So even if you take, like, for example, NHBRC is a public entity. It's related to government. So that's where the focus is. But I think my colleague, when she presents, I think can give you more information on that.
I just don't want my province discriminated against.
Sorry, Commissioner, maybe the roads needs to be fixed first. Commissioner, I think I'm on paragraph 24. MST is in default in terms of its financial obligations or servicing of the loan. Its defense is that the adverse media coverage has done immense damage to its reputation, and consequently it is finding difficulty securing additional business. On 8 May 2018, MST wrote to PIC accusing PIC of being complicit by its silence to the media allegations of wrongdoing on its part, and this negative publicity was affecting the finances of the company and causing delay in the issuance of its annual financial statements by its auditors. This is based on articles carried by City Press in September 2017 and in May 2018. I'd just like to also mention that the Commissioner, that the client is saying that hence it had changed its name. from MST to, I forget the name of what's its recent name. But if we look at the issue with regards to the annual financial statements, Commissioner, is that I don't think that what is said is true. It's because of us. I know that the auditors are reluctant to sign off because of the coverage in the media, but some of the part of that financial statements was before these stories came out in the media, so there can be no excuse for non-issuance, for example, of 30th June 2016 financial statements. MST has applied to PIC to restructure its facility. The proposal was tabled to PMC unlisted investments, but was rejected primarily because the PIC has experienced great difficulty in obtaining audited financial statements for the years 30th June 2016 to 30th June 2018. However, more importantly, there is a lack of cooperation by MST in providing information on the buses to enable the registration of special notarial bond. In addition, there is preliminary evidence to suggest that PIC funds were not wholly and exclusively used for the construction of new buses. I think a lot of that detail would come out from a post-investment team's testimony. PMC Unlisted Investment has approved that the restructure proposal not be considered. An MST must be issued with a default letter, and in the event that the default is not remedied within the agreed period, PIC should exercise its rights in terms of the agreements concluded. I'd just like to mention that on this particular case, we have issued that letter. It has not been remedied, and a demand has been made for the acceleration of the entire loan amount that the lawyers have issued. Chair, in conclusion, I'd just like to say, this year we see it as a sad state, given that this project, if we look at what it's intended to do, I think it's a very good project that can improve and touch the lives of many South Africans, particularly youth, and that's the sad thing about where we are today. Thank you, Chair.
Mr. Raja, can I ask a couple of questions? Because I think that, and obviously it'll be also covered in the next witness, but your preliminary evidence to suggest that the PIC funds were not wholly and exclusively used for the construction of new buses, from the documentation that I've read, it looks like there were no buses manufactured at all, and that there were different reasons given, including rekitting of some buses, but the chassis numbers couldn't be traced, and then different arguments as to why it was required. The first would be to, as you indicated, they got a loan from, or funding from Mercedes, and then the argument given is that that funding would be to enable MST to explore other chassis suppliers without being limited to Mercedes-Benz. So you borrow money from Mercedes and they're not bound by their chassis, so you borrow money from the PIC in order to not be bound. It just does not make sense in terms of the approvals. And then in the minutes of the meeting of the PMC Unlisted, which was in July 2015, it says the reason was to meet its order book. So the loan was given to meet its order book in one set of documents, and then in another set of documents it was to enable it to explore other chassis suppliers, and in the end there's no bus built. So what happened to the 21 million altogether? And then in your annexure D, is this normal for the PIC to precondition loans? The committee emphasized that MST should improve its BE level through incorporating a female BE group in the shareholding and a female at operational level. Would that be standard procedure that you would say to get our loan, this is what you need to do, and therefore fundamentally alter the composition, nature, accountability, competencies of a company? I'm not disagreeing with the question of empowerment, but I think that if I was running a company and I had a determination that this would alter my functioning and my competencies as to have a precondition met of this nature, how do you take accountability? How do you make the entity accountable if you're imposing those kind of conditions? And is it standard to impose them?
Through you, Commissioner, I think, Ms. Marcus, the question with regards to the application of the funding, I agree that it's when we look at what is in the appraisal document or the approval, what is carried forward into the legal agreements state new buses. And I think that has become the source of disagreement between the client and ourselves, because the client, it would seem, based on if we review the documents, that the team would have spoken to them about not only new buses, but when it came to the agreements are concluded on the basis of strictly new buses. And so on the legal side, that's what they are sticking to, is that you've signed that it will be new buses. But the client is contending that was not the discussions, notwithstanding that they had signed on new buses, and that's the where there's a big disagreement. So yeah, I think.
But surely, as yourselves, you've agreed to it on the basis of the legal documentation.
Yes, we agreed on the basis.
So
we are pursuing on the basis of the legal agreement. So that is what was signed, and I think it's fair to say that if you're signing the legal agreements, you have reviewed it, you've contributed. It was not a quick process. So you would have applied your mind to it. So we are sticking on the basis that it's for new buses. And I think that, speak under correction, I think that the team was only able to verify one. They had provided 8, that they sent the team around in circles, many times traveling. I know they had even traveled into Mpumalanga to even look at buses, but the client in the initial stages was so convincing that at some point I even doubted my own team. But as you go on, you can see that there's not a willingness to open up and be transparent, because it's a case of we can always look at how we can come to an amicable arrangement. But right now, it's very difficult to get information from them. And hence, we've taken the decision to call up the loan and exercise our rights. And we've rejected the 3 proposals that they made to us, because the 3 proposals made to us is to inject more capital into the business, and we're not prepared to inject more capital into the business.
can I take you to the UIF mandate document of July 2015. And there you've got a shareholding for MST, which relates to paragraph 3. Can you just tell us a little bit about that shareholding? And when you had a conditions precedent, you said that, or it had to provide that the tax affairs were in order. Would that be as MST or also as the individual shareholders? And how would you assess the question of the shareholding in that sense? I mean, is this what you would have examined? Both 3, because 3 relates the names of the organizations or trusts, and I'm assuming the 3 in the paragraph gives the names relating to it. Can you just talk to that a little bit?
Sorry, Commissioner, can you just tell him which annexure you're looking at?
That's a very good question, because I had it as a separate sheet, and I'm not sure it came in the annexures, but it is the 16th of July Social Infrastructure 2015 UIF mandate. and it gives a synopsis of the salient features of the project. It doesn't come under a tab, it came separately.
Well, Chair, through you, Commissioner, I think I would remember there was we've painted the picture of the shareholdings,
Yes.
which have been, would have been through companies and trusts. So there where we had examined the shareholding, about 60% of the shareholding was related to the main sponsor there, Mr. Fernando Acafrao and his family, and then there are two other, I think, shareholders, one of which is Mr. Reggie Kukama and Mr. Jonathan Bear, through their companies, are in the shareholding as well. That was examined at the time of the due diligence.
And would these shareholders have been informed of the state of affairs of MST as we have it now?
I cannot confirm that now, but we can confirm post the meeting. I'm not aware of that.
I would think that's quite important because I mean it's again I'm not able to see who is who in relation to the companies. But you've got Yaitsho Investments, which is 20%, Plumari Family Trust 10%, Rapid Relief Trading 5%, FA Children Trust, which I'm assuming is Fernando Acafrao, 60%, and Buffshell 57 Trust 5%.
Yes.
So I'm assuming that the people relate to that, and
Yes.
I would want to know that all of the tax matters related to the individuals as well as MST and those companies are also in order.
We will confirm that, but what I can say is that at least at company level we would have checked the tax affairs of the company, but I'll confirm whether that was extended to shareholders as well.
And whether those shareholders are all informed and are fully aware of the state of affairs of MST as it stands today, the question of inability to get audited financial statements and the prospects of its business continuing in a profitable manner going forward.
We will do that, Commissioner. And the question related to on the imposition of certain requirements insofar as introducing female at shareholding level and so forth. What would normally happen, if I can explain to the committee, is that you'll have the deal team which will do the due diligence on the commercial side and the risk. Then you have an ESG team, legal team, and risk team. So the ESG team, independently of that, would come up with their own recommendations. And they would put in recommendations in terms of trying to improve, as an example, the BBB status of the company. Normally that won't be a condition precedent, but it will be an undertaking, and usually they would give them between 18 months and 24 months within which to achieve that. So that is what the ESG recommendations that are tabled at the approval committee, and if the committee approves of that, that would become the condition. I do take Ms. Marcus' point in terms of imposition of certain requirements could end up, well, you could put yourself on the back foot, because if things go wrong, they'll probably say it's because of you. And I take that point.
In that circumstance, as you've made a recommendation, as indicated in 10.9, emphasize the MST should improve its BE level through incorporating a female BE group in the shareholding and a female at operational level. In those circumstances, does the PIC ever make recommendations of names, or does it leave it to the entities?
Through Commissioner, we won't make a recommendation of names. We would leave it to the entity, but on occasions it might be subject to us agreeing to who those people or individuals are. But we would never make that recommendation.
Does the PIC have someone on the board of the company?
In this particular instance, because it's a loan, it doesn't give us that right to appoint a board member. Yeah. But if we were in shareholding, we'd probably have the right to appoint usually one or two people.
My worry is that it seems that there are times when the PIC struggles to get the financials, of companies. It was the Mozambique company, which is a bit different because it's a different country in many ways, but we still need those. But here too, you are battling to find the financials. What causes that? Companies must do financials. And why can't they do them and send them to the PIC?
Look, through your Commissioner, in this particular instance, firstly, I believe that for 30th of June 2016, the company has no reason not to have provided that. I could understand that maybe with all the negative publicity that surrounded the investment, that the auditors probably are very cautious and taking the view that they don't want to sign. I'm inclined to believe that that might be the case, but definitely not for June 2016. What has been provided to us now is a watered down version of an audit because the Companies Act allows for it. But our agreements is very specific. We want audited financial statements that is applicable to the normal companies that are audited, and that has not been forthcoming. I think the client is doing this to pacify us in the meantime of giving us a watered down version of financial statements. We need a higher degree of assurance in terms of a full audit.
And given what has come to pass, what has gone down with this investment, is there something that you think you could have done better in terms of the investment process on this company?
Through your Commissioner, I think, look, I don't think that we could have done more. I think, sometimes when you get involved in these investments, only with retrospect, you begin to understand the team better. But at that point in time, we were quite confident. If we looked at some of the let's call it the non-active shareholders, one of them at least would have given us a lot of comfort in there, because we know the person as a solid business person.
What is his name?
Well, in here it's Mr. Jonathan Bear.
Mm-hmm. Mm-hmm. Yeah. And so, do you check the track record of the businesses? Like somebody comes and say, "This is my company." Do you check if they've done more companies before, the relationships with shareholders, creditors, those kind of issues?
Through your Commissioner, yes, we would have done so, and if there was any adverse finding, like for example, we would do the normal credit checks as well, the CIPC checks in terms of what other businesses they are involved in, because you've got to ascertain whether there's also risks of shifting of profits. So those are done during the due diligence phase. Quite a bit of work is done on that.
Perhaps just one additional point, again referring to that UIF mandate. Part of the information provided is in terms of social impact, and it says approximately 224 permanent jobs will be created post-construction and 300 direct and indirect during construction. So there was no ambiguity that this was to construct buses.
Yes, it would have been new buses.
It would be new buses for construction.
It could not have been just kitting.
Could not have been re-kitting with that kind of information. Yes. And then secondly, if I could ask you to please check whether, given that you have mentioned his name specifically, Jonathan Bear, as a shareholder, whether he is aware of the state of affairs of MST.
We will do that.
Commissioner, that concludes the testimony of Mr. Raja. May I request a 10-minute adjournment to allow Ms. Matjila to take the stand?
Yes, before we adjourn, thank you very much, Mr. Raja, once again for coming to testify before us. Thank you so much for the information.
Thank you, Commissioner.
Okay, that doesn't mean it's the end of you. You might come back at some other time. We'll adjourn until 11:15. Ms. Matsikanda, are you the next witness?
Yes, Commissioner.
And I'm sure from yesterday you still remember about the oath, taking the prescribed oath?
Yes, Commissioner.
No objection to do it again?
And no
Can
objection.
you just stand up, and do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? Raise your right hand and say, so help me God.
So help me God.
Thank you so much.
Thank you, Commissioner. Ms. Matsikanda gave an overview of the PMV department and its role yesterday. So if Commissioner allows me, Ms. Matsikanda is going to start at paragraph 11 of her statement.
Handing over of the MST transaction.
That's correct.
Yes, thank you.
On the 21st of June 2017, the PMV department and other relevant departments attended a handover meeting in respect of the MST transaction, which was convened by the Isibaya operations team. The PMV department was represented by Mr. Leseho Mutupi in his capacity as a PMV associate. The purpose of the handover was for the transaction team, also known as the deal makers, involved in the MST transaction, to brief the representatives thereof, amongst others, PMV, ESG, Finance, and Isibaya operations of the transaction and the investment thesis. Following the meeting, a disbursement memo prepared by Isibaya operations was submitted to me for signature. Based on the disbursement memo, together with supporting documentation, including the transaction agreement, I gathered the following. A funding of 21 million in favor of MST had been approved for the manufacture of 7 buses, which had been ordered by 2 customers of MST. An extract of the minutes and the resolution of the meeting of the PMC, whereat the MST funding was approved, are attached as Annexures 1A and 1B respectively. The funding would enable MST to explore other chassis suppliers without being limited to Mercedes-Benz.
Sorry, can I just ask you in relation to that? It is for the manufacture of 7 buses, but in the original proposal it was 14 buses. How did this amount of money go from 14 to 7? And in your examination post the investment, were you able to identify how many buses of this nature were in the fleet that was being operated or had in fact been manufactured by MST, so that we would know the proportion of 7 or 14 in relation to the whole of what MST was about? And then in terms of your 12.3, to explore chassis suppliers without being limited to Mercedes, my understanding from what was said earlier was that the funding was reduced from the 45 million, 30 million down to 21 million precisely because there was a funding from Mercedes that had been obtained by MST. So why would this be a rationale for the lending, that you would want alternative suppliers when they've just obtained exactly that role in the funding through Mercedes? You know, it seems to be contradictory as to what the purpose of the money was in the different times. It was the question of saying it was for expanding the business, it was for the question of, to enable MST to explore other chassis suppliers, but it was also for the ability to expand the order book, same money being used in different objectives, but it's the same money. If you could just clarify some of that for us.
Thank you, Commissioner. In my understanding, the initial 14 buses that are in the appraisal report would have included 7 whose chassis had been or would be acquired from Mercedes. But from that appraisal report, it seemed there was a challenge in having only Mercedes as the funder or supplier of the chassis, and hence they requested funding which would enable them to explore the chassis procurement from any other supplier without being limited necessarily to Mercedes-Benz. The actual number that was then funded, being 7 buses, could have been procured from Mercedes or any other supplier, but it was essentially meant to procure 7 new buses. Hence, the funding would have moved from 30 million to the 21. So the 21 would involve 7 new chassis and the body as well, which would then become what is the client is now referring to the kitting out, a portion of the funding. So from the resolution, you will see that initially it says that the security will be split from between Mercedes and the PIC. So that would have been, if the 14, the application for 14 had gone through as 14, they could have procured the chassis still from Mercedes and split it with PIC in terms of the security package. However, our 7 is what was concluded and signed on in the transaction agreements, and that is what we pursued to verify in the facts that I provide hereafter. As security for the funding, amongst others, the PIC would register a special notarial bond over the bus units, as well as a general notarial bond over movable assets acquired from the proceeds of the funding. The term loan facility agreement, which I refer to as the agreement, and the conditions precedent satisfaction letter had been signed. I attach a copy of the agreement as Annexure 2. In terms of the agreement, the borrower is required to, amongst others, apply all amounts borrowed by it under the agreement for the purposes of designing, constructing, assembling, operating, and leasing of bus units as per clause 4.1. The purpose of the borrower would also be submit to the PIC audited financial statements by no later than a period 90 days after its financial year end. On 29 June 2017, I signed the disbursement memo on the basis of the documentation that was provided to me, as well as an email from Mr. Matupi, which I attach here to as Annexure 3.
Thank you. If we could just go to 12.4, the registration of your SNB, that would require certain compliance to have been done. For instance, the actual manufacture of the buses prior to registration?
Yes, Commissioner. So the special notarial bond would entail us satisfying ourselves that there are 7 buses that actually exist and are identifiable, and the mechanism of identifying them would be the registration documents, which would give us a vehicle identification number, which is referred to in the statement as a VIN number, as well as further to that having physical sight of those buses before we can proceed to have our lawyers lodge and register the SNB.
Has that ever been registered?
No.
So that there hasn't ever been compliance with the requirements for registration?
No, Commissioner. We have over a long period tried to verify through at least 4 site visits, but we've only been able to match 1 bus of the 7 listed in the documents provided, and the rest that we have been given security documents for referred to registration dates of buses that were manufactured from as far back as 2011, which is what we've established, that there are no new buses that were actually manufactured from the funding, but it's taken a process of at least 4 or 5 site visits to have ourselves confident that there is actually no new buses that were manufactured.
Do you know what actually happened to the money?
We did request a breakdown of the usage of funds at some point, and that breakdown is one of the annexures, which refers to various components of a bus, such as electricals, plumbing, hydraulic systems, air conditioning, and only 2 chassis of that list is indicated as having procured from the 21 million. And based on that breakdown, it is where we then establish that there's a misalignment in the application of funds, because it's unlikely that PIC would have approved funding for the components of the body of the bus without the chassis, because that would then contradict the reason or the requirement for a special notarial bond. So the client, as Mr. Raj alluded to earlier, is disputing that the original agreement was that they would acquire new buses in the first place. They have said that discussions right from inception were that they would use the funding to kit out. And on the basis of that, that's why we have now taken the matter to external legal counsel. Most of this detail is covered in the statement, which I'll go through still. But that essentially is the nature of the transaction as it stands. Okay. Introduction to investee company. PMV established first contact with the client within the month of disbursement, which was on the 31st of July 2017, to request an introductory meeting and site visit and security verification. There were various requests to confirm a meeting date from July 2017, and the client was only able to confirm this visit for the 1st of November 2017 at the client's Johannesburg premises in Lenbro Park.
Sorry, can we just stay with that a second, and it may be within your area or not. Would a situation which takes that amount of time to enable a site visit not have raised concerns about why would this not be something, if you're wanting to get a loan, that you're not available the next day?
Chair, the client indicated at that time they were busy with the procurement of the buses and the manufacture as it is provided. There were requests for update as to where are we in terms of manufacturing these buses, how many have actually been manufactured, how many have you taken delivery of, and they confirmed at some point, which I referred to, that they had indeed received at that point 6 of the 7 buses, and therefore in terms of the verification, what we understand is the manufacturing process takes about 3 to 4 months. So us going to the site visit in November would have been exactly 4 months after disbursement, and that at that point was a reasonable time still to make a first attempt to physically verify. But in terms of introducing ourselves to the client as now the custodians of the investment, the effort started in July to get a meeting, but was only confirmed for November. Steps taken in monitoring the investee company. Security verification and registration. On the 6th of September 2017, Mr. Matupi sent an email to the client requesting an update on the number of buses that had been manufactured and delivered to MST, as well as an operational update as per the agreement. A copy of Mr. Matupi's email, as well as subsequent correspondence, are attached as Annexure 4. The following day, the client responded that 6 of the 7 buses had indeed been delivered and that the 7th bus would be delivered in the following week. On October 2017, Mr. Matupi wrote an email to the client asking for the particulars of the buses to be registered under a special notarial bond. These particulars were then sent on the 30th of October 2017, prior to the first meeting. The client provided the list which contained VIN numbers of 7 vehicles, which are also in Annexure 4. At the meeting on the 1st of November 2017, a bus tour was conducted. However, the client informed us that the buses on site were not the PIC funded buses, as those had already been deployed to service the customer contracts in different parts of the country, including Cape Town. Following this meeting, a new list of VIN numbers was provided by MST to members of the transaction team, who in turn forwarded by email such list to Mr. Matupi on 13 March 2018. Copy of the email to Mr. Matupi is attached as Annexure 5. It is to be noted that the contents of this list differ from those contained in the list that was provided in October 2017. The second attempt by PMV to physically verify the list of buses that was recently provided was on 15 March 2018. This was at a meeting and site visit with MST management in Cape Town. The PMV department was represented by myself and Mr. Mutupi. The purpose of the meeting was to, amongst others, discuss performance and conclude the security package verification. At that meeting, we only managed to verify one bus from the 7 VIN numbers provided by the client, and this bus had NHBRC branding. I refer to Annexure 5 for that. At the same meeting, the client's financial position was discussed, and based on the existing contracts and management accounts at the time, there were areas of concern regarding MST's ability to service the debt. However, based on the pipeline of contracts considered at the meeting, it seemed the client would be in a position to service their first installment, which was due on the 6th of July 2018. This was subsequently confirmed by the report sent by the client dated 23 April 2018. A copy of the email is attached as Annexure 6.
Sorry, Ms. Matsikane, what did you conclude? What did you think at that meeting when you were not able to verify anyone but one bus?
Commissioner, at that time, the client indicated they were not able to recall all buses to have all 7 stationary for our verification purposes. But what was on site and what was on our list is what we could verify. So of the 7, we only saw 1, and the rest, they said, were operational. Hence, we couldn't have seen all 7 at the time.
Sorry, I might have missed it. Did you get an explanation as to why there were 2 separate lists and different?
I can't remember what the explanation at this point was. But it then is apparent even after that the list kept changing. So even the final list which we have today is different from the first 2. And this is what we are establishing as that there is actually no specific PIC security. And what we've been given is what they have in stock from what they procured a very long time ago. After the Cape Town meeting, Mr. Mutupi conducted another inspection visit on 23 March 2018 at the Johannesburg offices. Between April and June 2018, various correspondence continued to take place between PMV, the transaction team, and the client to clarify the security package. On 13 April 2018, Mr. Mutupi sent an email to the client and amongst others raised the following findings from the vehicle inspection efforts at the Cape Town and Johannesburg offices. As opposed to 5 buses, only 4 being used for the purposes of the RTIA project were identified. And as opposed to 2 buses, only 1 bus being used for the purpose of the NHBRC project was identified. In the same email, Mr. Mutupi requested the client to provide an explanation as to why one of the buses is being refurbished, whilst MST is required to manufacture new buses from the facility and provide information on the exact buses that were manufactured utilizing the facility, including VIN numbers, engine numbers, and registration documents. That is also contained in Annexure 5. On 7 May 2018, and after various correspondence from the transaction team and Mr. Mutupi, I addressed an email to the client regarding their non-compliance with the agreement as it relates to, amongst others, the requirement to register the special notarial bond and the consequences of such non-compliance. In their response, on 8 May, MST disputed non-compliance with the agreement. A copy of the email is attached and marked Annexure 7. On 31 May and 1 June 2018, the client was requested to provide a breakdown of how the funds were utilized. From the client's submission, it was discovered that only 2 chassis were purchased and the balance of funds were applied towards various internal fittings for 7 buses. Copies of those emails and the submission is attached and marked Annexure 8A and 8B. In light of the client's submission, we convened a meeting with the client for the 12th and 13th of July in Cape Town, where, amongst others, we sought to ascertain the reasons for the misalignment in the application of funds. to identify buses in respect of which the funds were utilized, and to discuss the default on payment of the first installment, which was due on 6 July. In relation to the asset verification exercise, we were shown some buses that were on the premises. Of those buses, none appeared to be new, and this was subsequently evidenced by registration documents that the client sent later that day. A copy of the email and attachments are attached here too and marked Annexure 9. During the meeting, we requested a final asset list to ascertain the extent to which our loan security could be enhanced further in the circumstances. The asset list provided showed a fleet of 27 vehicles reported to be on MST's balance sheet, and of only 6 of these were unencumbered buses. A copy of that asset list is attached and marked Annexure 10. From the period after disbursement up to July 2018, PMV and the transaction team had been corresponding with TGR attorneys who were mandated to register the security package. And TGR attorneys had been requesting the asset list on various dates, and PMV would provide update on the status of verification. During November 2018, our internal legal proposed that we send a list of 3 other law firms to the client to consider contracting with one of them for the purposes of registering a special notarial bond on the unencumbered buses. The list was forwarded to the client by Mr. Mutupi on 22nd November 2018, and copies of relevant correspondence are attached as Annex J11. The client responded on 11 December, indicating that the directors of the company were not willing to incur any further costs until they afforded an opportunity to meet with, quote unquote, key decision makers within the PIC. Compliance reporting undertakings. From December 2017 to date, various emails have been sent to the client requesting audited financial statements from 2016 up to 2018. The client has been committing to providing the requested information but has not delivered on any of those dates. To date, the client has provided different reasons why they could not submit the audited financial statements. The copies of the relevant emails are attached here to marked Annex 12.
Sorry, can I just stop you? Can I take you back to paragraph 15.18? Did the client, do you know who the clients were talking about when they said they wanted an opportunity to speak with the key decision makers? Do you know who they were talking about there?
I think from this email we established they would have wanted to meet with the executive head of impact investing and or his senior. But we did respond to this to reiterate that there is no key individual that is able to make a decision about any client's requests in isolation without taking such requests to a committee. And therefore we did notify them that in whether or not they were to meet the key executives, we would be the first place, in the first place, the team that would assess whether that request or whether any of their representations are necessary to take to a committee for approval. Point 16.2, it is to be observed that the client has reported that there are challenges in getting their auditors to sign off the statements, as the auditors have expressed unwillingness to sign the audited financial statements on the back of perceived reputational risk of MST as a result of their association with PIC. However, it appeared from their correspondence with their auditors that the auditors were unable to finalize the audit on the basis of a possible reportable irregularity. That is also contained in Annexure 12. The failure to submit the audited financial statement has impeded our ability to assess the financial position of the client in full, as we cannot place reliance on the management accounts. Debt servicing. The MST loan facility has a tenure of 7 years with biannual repayments due in July and January of each year. The client has failed to repay the first and second installments on the loan due on 6 July 2018 and 6 January 2019 respectively. As mentioned above, a meeting was held with the client during March, being 3 months prior to the installment due date, to determine, amongst other things, whether the client was in a financial position to start servicing the loan. Another meeting was convened on 12 July 2018 to discuss the default on payment, non-compliance with reporting undertakings, and failure to register the special notarial bond. The MST management team indicated that they could only afford 420,000 of the 2,243,238 rands and 41 cents due to the PIC. The team agreed to the part payment and requested MST to submit a debt restructuring proposal in relation to the balance. This 420,000 was paid on the 13th of July 2018. At the same meeting, the client further requested a repayment moratorium for a period of 6 months. In order to enable us to consider these proposals, we requested MST to provide us with June management accounts, outstanding 2016 and 2017 audited financial statements, and all existing contracts, their deal pipeline, and projections for the following 12-month period. To date, all audited financial statements remain outstanding.
Question?
Yes, sir.
Just to check, in terms of PIC processes and systems in debt collection or, security packages, debt collection, servicing debts and all that. When you borrow money from a bank, you service your debt immediately, and if you're not paying it, they write letters, they come for you. And I'm just wondering, when you compare the systems that banks use versus what the PIC is doing, it seems that there's a huge gap there. Would you want to comment on that?
Indeed, Commissioner, there is a difference in the banks and how PIC processes are at present. With banks, they are automated systems which send out those notifications of payments due. In the instance of PIC, we depend on the loan amortization schedules which are kept by the finance team, but because when we are monitoring, we keep track of when payments are due, and on the date of payment, we liaise with finance to establish whether or not the bank accounts, they have traced that payment that's coming from the client. And if after finance confirms that there is a payment indeed, or there isn't a payment, we then proceed to discuss or engage with the client as to the reasons. But even prior to that, we always seek to establish a few months before the payment is due, whether or not the client will be in a good financial position at the time of the loan installments being due to repay the debt, which is what we did with MST in this instance, 3 months prior to the loan being due. And we got reassurance from the client that they would be in a position to.
Yeah, so are you happy currently with your systems and the way things are, or would you like to get closer to the bank's processes and systems?
Commissioner, it's a significant area that would really improve our processes if we could get an automated system to assist us to track such things and issue breach notices and default letters at the point where the defaults and these breaches occur, rather than having to first initiate a document that must go to legal for them to draft and then have us review and revert to the client on the breaches. So that would explain why in some of these instances you'll find that the default letters are sent a couple of weeks and maybe in some instances more than a month after the actual default event has happened. So it is an area of improvement which I referred to yesterday in my recommendations, that it would assist the team greatly and in managing and minimizing losses of the PIC to have a system that assists us with such dispatching of these notices as early as possible.
Yes, because this is a manual process and things, slip through the fingers, and it seems it's quite a difficult thing to do, from the PIC side.
I agree, Commissioner, but we try to have these gaps covered it is difficult to discharge duties when you have to keep track of all of these requirements or all of these reporting undertakings and compliance areas from a manual point of view. But I understand that there is a system that is being explored, and possibly within the next 12 months we should be able to improve our administration processes around that.
And how many of such loans are you looking after, as a department, in terms of number, roughly?
In terms of the number of clients, it's about 100, but you'll find that in some instances, one client will have more than one type of instrument. So within one client, you could have up to 5 different loans, loan facilities and equity instruments, or various types of instruments. So if on average, I say one client has 2 or 3 facilities, we're looking at about 200 or so loan facility agreements that you would be referencing.
And do you have the same problem with the security packages, the follow-up, and to make sure that the notarial bonds are being processed properly and all that? Besides now the debt servicing, do you have other processes that are better in terms of the security packages, which is a struggle, from this side also?
In terms of the security packages, most of them are usually intact at the point of approval or disbursement. Where a special notarial bond is required is after the client has been given the funds and they have to go and procure or manufacture whatever it is the purpose of the funding was. We have not, in my portfolio, we've not had a problem verifying a security on other investments. This is one where we've committed quite immense efforts and a lot of time in trying to complete that process. But I don't remember any other in the portfolio that have given us this much difficulty.
Yeah, because you see, if you are not following up and people are not seeing notices, isn't it that, people just say, I'm not going to repay this, if they're not seeing effort and, from the PIC to say, you need to pay this loan. Isn't it correct?
It's correct. All clients, by virtue of signing legal agreements, undertake that they will make a payment on certain dates, but where they are not able to, they do refer. Some will notify us ahead of time that we are having liquidity challenges, and hence that would require us to initiate a restructuring process prior to the date of installment falling due. In other instances, we then pick up the defaults after they've happened, and we then try and resolve either by extending the repayment or whichever mechanism we agree with the transaction team to restructure the payments.
All right, thanks.
In terms of quarterly reporting and the performance rating, the first report on MST was for the quarter ending September 2017, and MST's risk classification evolved as follows. In September 2017, we classified it as performing, although there was a cautionary concern reported as there were variances against the initial projections. In December 2017, it was placed as a watch list investment due to the security issues that we could not complete, we had not completed at the time. In June 2018, and you'll notice that between December and June, there is no much performance rating because, as I alluded to yesterday, in March we do not submit reporting as it is a financial valuation, year-end valuation process that takes place and supersedes our processes. In June 2018, the investment was placed in distress because of default in repayments and the continued non-compliance in reporting. September and December, they've also remained as distressed because of the continued default position. Under financial performance, from the first quarter after disbursement, the investment reflected strain, loss-making, and deteriorated further until the loan was fully impaired in September 2018. The breaches and non-compliance with registration of special notarial bond and the repayment defaults were reflected in the quarterly reporting submitted to the various committees at each quarter. On the 3rd of October 2018, PMV attended a PMC meeting scheduled to report and discuss distressed investments, one of which was MST. This was a combined meeting for PMV and ESG teams to discuss quarterly PMV and ESG reports, respectively, for the quarter ending June. At that meeting, I was instructed by Mr. Rajda not to discuss the MST transaction. He also asked me to inform my ESG colleagues, Mrs. Bahangwede Banavela, that we should not discuss the MST transaction rather. As a result, the issues on the MST transaction were not discussed at this meeting.
Can I stop you at this point? Do you know why Mr. Raja said you shouldn't bring up the MST issue at the PMC meeting?
He indicated that at this point it wasn't a factual, he wasn't comfortable that the facts were specifically that there had been no buses, and because the client would insist in fact that the buses are there somewhere when they would discuss with him, he wasn't comfortable that at this we appraise the committee and say for a fact that there are no buses. I think he wanted us to explore the matter further and see if there could be any more that could be done before we place it on record that indeed there are no buses.
And this was almost a year later.
This was almost a year later, but the subsequent quarters would have also highlighted that information in the quarter. It's just that at this meeting, it was specifically to have a discussion with the committee and have them note that these events have taken place. But he was uncomfortable because he felt from, I think he's alluded to it earlier, that the client would make different representations, and at some point he felt there was a doubt that we were actually had done enough to find these buses, hence why he said he would rather not have us speak to the matters in that meeting.
Thank you.
But was there any doubt by that stage that there may or may not be buses? I mean, you had been to Cape Town once or twice and never found any 7 new buses.
We hadn't found any buses, indeed, and what we had been given as registration documents related to buses that were old. But because they would want to see key decision makers, and he alluded that he had spoken to them, they would say that everything is in place. So I think from his perspective, there was doubts that we were doing the correct thing or we were following proper processes and applying full efforts to this because the client is saying something contradictory. And to this date, they still maintain that in the first place, you shouldn't be looking for new buses because that was never the agreement. So at that point, he did say that it would be a bit premature to say that there are no buses because we still have not satisfied ourselves that this is the matter.
Yeah, I'm not sure that I'm satisfied with that. It bothers me. On the one side, client is saying, we never said we are going to manufacture or have 7 buses manufactured. We were not talking about that at all. And on the other hand, you are saying, we don't know whether there were new buses manufactured or not. And how do you reconcile those two?
Commissioner, it's something that's been difficult even to this point, which is why the matter has been taken to PMC to give or make a decision about what is the next action that we can take to satisfy ourselves that indeed there's a distinct contravention in the legal agreements. We, basing on what submissions client had given us for the security package, it was not aligned with what we were following up on in the legals, but they would say that that was what we were following up on is not the spirit of the agreement in the first place. That is where the two issues where we diverge with the client is that they're saying you shouldn't have been looking for new buses in the first place, and you are aware of this because at DD stage they referred to in an email that the PIC funding was agreed to have just been a general commercial facility rather than a specific funding facility for the 7 buses. So because of this divergence, we had to get a PMC approval to say how do we proceed given the client maintains their position being they were never meant to comply with new buses, and we are saying we've always known that the funding was for new buses. So the PMC decision that's been taken in this regard is that issue a default letter and just accelerate on that facility and recover what you can. And this has been referred to external legal counsel to deal with going forward.
But I'm sure you realize that you will never find 7 new buses.
I don't think that the buses, there are no new buses, no, but there are buses that we have been given, and as I alluded to earlier, they are as old as 2011.
Yeah, a broad question, coming from that point, and I do know that you still have to talk to the transaction team, but are there Chinese walls between PMV and transaction teams, broadly?
No, Commissioner. In fact, the level of engagement with the deal team is quite robust and very frequent, to the extent that where we start to experience difficulties in having the client responding to our requests, we always rope in the transactors to assist us, and they do come in. They are meant to be kept abreast of all the developments on their transactions because they have contracted on a particular set of numbers that they have deemed are achievable in the future. There's a target return that is given in appraising the document and getting it approved. There's a target return that we always, or they seek to achieve. And because of our efforts of monitoring, we have to notify them where we start to see the divergence in what the base case was, which was the basis of facts which the transaction team would have had to relate to the committee for approval. Once there's a divergence with that base case, we have to keep them involved because ultimately the accountability within PIC for transactions is with the deal team. So we speak to them on a very frequent basis, and you would see from the statement that I refer to all engagements having come from the different representatives of their teams, our teams, and the other teams.
But they cannot stop you from making some conclusions or whatever. I mean, you do speak to them, but they cannot influence you in any way, broadly.
They cannot influence the activities we seek to undertake to establish what the facts are, but they because they have to review with us any documentation that must go to PMC. They review and they sign as reviewers and co-compilers. To that extent, it is necessary to have ourselves and the transaction teams on the same page, because then if there is a divergence in views, some of the documents we would require to take to PMC cannot be approved, and that is why even the submission of the document itself is subject to the executive head of the deal team signing that is comfortable with the facts that are contained and that are being submitted to a PMC.
All right, no, fair enough, fair enough.
On client's request for restructuring, on the 5th of September 2018, the client informed us that they were in a better position than the last time we met and would be sending a well-motivated proposal for our consideration. On the 7th of September 2018, the client accordingly sent us a proposal with the following 3 options to consider. First option, to defer payments to April 2019 and commence monthly repayments instead of the biannual repayments. Second option was to further advance 9 million, which the client indicated would be used to settle some of their creditors, then commence PIC monthly repayments from October 2018. And third option, which they said was the first price, is to increase the facility by 24 million to enable MST to repay other lenders and creditors first, then start paying PIC monthly repayments from October 2018. A copy of the proposal is attached as Annexure 13. After considering the options, we discussed together with the transaction team and decided not to support option 2 and 3, and that only option 1 may be further entertained on condition that the client provided the outstanding financials. Upon the client's failure to provide the outstanding financials, we issued a default notice on 12 September 2018, noting the various contraventions of the legal agreements. A copy of the default notice is attached to and marked Annexure 14. In January 2019, we noticed that the client has rebranded itself utilizing a new name without notification of the change of name in contravention of the agreement. Upon inquiry, the client informed us that it undertook the rebranding exercise as a result of the negative media publicity associated with the PIC. The client further failed to provide the long outstanding information regarding the company's strategy and repayment plans and insisted that it will provide this information at the meeting with quote-unquote key decision makers. Copies of the email correspondence is attached as Annexure 15.
My apologies. So on paragraph 24, the client didn't inform you that they had changed their trading name. They just did that. You picked it up.
Yes, we had been corresponding with the CFO, and after one of the emails in January 2019, we picked up that his email address had changed to @extend.co versus @MST Group. And we specifically sent a letter prior to sending that letter, we asked our ISBA operations team to assist us to check on the database whether the name Extend Mobility has the same registration number on the CIPC as the MST name. And from there, that's where we established that the name change is actually that MST is no longer MST but Extend Mobility. And we then asked just to have it confirmed by the client that they indicate if that was indeed a name change. And in email correspondence, they then confirmed that in fact they had undertaken the full rebranding exercise to disassociate with the impact of the negative publicity associated with PIC.
And from their point of view, they didn't see a problem with rebranding without actually communicating this with PIC?
It would seem it's not something they saw as necessary because they are required. It's a material change because our legal agreements refer to MST, and there is now a company called Extend. So I think just legally it would be necessary for them to notify us as a lender that their counterpart's name is no longer MST but that it is Extend Mobility, so that we can have an addendum to the legals indicating such. Internal decisions.
Paragraph, yeah.
Yes, sir.
Just looking at paragraph 20, the client, asked you guys to give them more money, but given the fact that you were struggling with the financials, the security package, and the buses, there was a dispute about them. I mean, why did the client feel that they could ask for more money, from the PIC?
Commissioner, I can't answer to why they felt it would be a considerable proposal to request us to inject more funding. If we're in the first place, the first funding has not actually been applied correctly. I don't understand why they would think this is a plausible type of option for us to consider, but we did indicate that whatever their proposal is would have to be considered with audited financial statements for us to get a good understanding of where exactly they are in terms of, are they going concern, are they still profitable, and is this a business that is sustainable?
Because I thought when you beg for more money, you must supply all the stuff to get the money, isn't it?
That is how it should be, but with this client, not.
Okay.
Internal decisions taken with regards MST. The client's non-compliance with reporting undertakings, in this case audited financial statements, and the lack of cooperation regarding the special notarial bond registration was tabled at the PIC meeting held on 26 February 2019. Due to the fact that a reasonable period had passed during which all team members had made efforts to ensure the fulfillment of the client's obligations to no avail, the PMC made a decision to refer the matter to legal counsel for the purposes of enforcing PIC's rights under the agreement. The PMC further resolved that another default letter be sent, and this letter was duly sent to the client on the 5th of March 2019. A copy of the letter is attached and marked as Annexure 16. The client has responded to refute the contents of the default letter and are requesting to meet with PIC to resolve the matter. The legal department has commenced with the process of briefing external legal counsel on the matter, and as a result, we've been advised to refrain from communicating further with the client until the legal team engages with them. But as Roy has alluded, Mr. Rashid has alluded earlier, this has already been communicated legally by external counsel to the client through another default letter as of yesterday. Commissioner, that concludes my statement on MST.
Question. So, I mean, this company or this work which the company is doing seems to be good work. Healthcare, education, and everything. Commendable work, but I'm just wondering, I mean, what in your opinion or what do you think actually went wrong? I mean, it seems like everything went wrong in this sort of noble effort with some profit potential.
Commissioner, indeed, the nature of the business of a company is that it has a high social impact. They are very visible in what are mostly remote areas where physical infrastructure for some of these government departments cannot be put up. Hence, they provide that mobile solution of catering to specific government department needs and ensuring the visibility of those government departments in different areas of the country. But in this case, what I think this transaction could have gone better had the buses just been manufactured as per specification of the funding. And secondly, if the client could just have cooperated and ensured compliance with reporting undertakings. And in my view, it can't be that the negative publicity related to the PIC girlfriend and girlfriend story has any bearing on whether or not they can conclude their audits, because the two are unrelated. Audits are audits and they are assurance mechanisms. I can't determine what exactly here was the problem, except that lack of cooperation and probably better processes within the client's systems themselves. But they are now using this non-compliance and using the PIC as a scapegoat for not being able to supply this information. And in refuting the contents of our default letter, they do indicate that every instance of non-compliance is at the behest of PIC's negative media issues.
Yeah. The final question is on the recommendations that you had yesterday. I just don't have the page now, but would that include the system you mentioned, the automated system and the other issues? Just if you could come again then mention them a bit again. Let's see.
Um,
Do you have the page by any chance there? The recommendations page?
No, I don't, Commissioner,
Your
but
own.
I am conversant with what I was recommending. In terms of what I recommend as being required, or what could further enhance PMV's processes, is it's a system that's automated, which enables us to gives us more agility in terms of responding to issues such as these. Why I mention it is because, as I alluded to earlier, sometimes the client may deem the period after default, if we haven't provided a notice, they may deem it as a condonement of that breach. And therefore, my recommendation is that if there is an automated system, you're able to dispatch these notices immediately as the event of default occurs. And that should ring a bell to the client to say that the PIC is aware of the non-compliance and does not waive its rights. In fact, we reserve our rights going forward. Whatever remedial action or remedial proposal, the client can come back to us to consider. So that the automation is essentially to assist us to discharge our duties and have these breaches noted as soon as they happen, so clients do not feel that PIC is soft-handed, or that they don't think that it's a condonement of those breaches or defaults by virtue of the length of time it has taken for us to issue those letters.
Okay. All right. Yeah. Thanks. I think I'm done for me.
Can I just ask, on your paragraph 27, the client has responded to refute the contents of the default letter. What are the grounds upon which they rely to refute the contents of your letter?
Essentially, they're saying that all the default events we have referred to in the notice of default or the letter of default, which is that there have been misrepresentations in terms of how the application of funds was utilized, and in that the purpose of the funding was for the manufacture of new buses, and as well as the failure to report. They're saying that all of these issues cannot be attributed to non-compliance on their part, and that all these material issues have stemmed from the challenges they've had to contend with due to the MST's and PIC's media articles. So what they're saying is, in fact, by us giving them a default letter, we are making serious allegations, serious and false allegations, according to them, to say that they misrepresented themselves in complying with the agreements.
I don't know whether you'll be able to, enlighten us on this issue. There were some allegations mentioned in the Budlender report. I am sure you remember there was investigations by Advocate Budlender in respect, and MST was one of those matters that he was supposed to look at. And he mentions allegations, and I mean they were allegations, that Ms. Pretty Low had some business relationship with MST. Do you know anything about that?
No, Commissioner. In fact, up until the media articles, I did not know of the existence of Ms. Pretty Low. And even pursuant to those allegations, I've still not met Ms. Pretty Low, and I have not come across her name or involvement in any of the monitoring that we've been doing. So I do not have any information on her involvement at all.
Fair enough, okay. And the last question from my side is, what do you think, are there any lessons to be learned from this transaction? Lessons in particular relating to whether the PIC should advance loans and not make sure that the money is going to be utilized for the purposes that it was, I don't want to use the term purportedly sought.
Commissioner, I would think on a transaction such as this, which is contract financing, maybe what could be considered going forward is instead of just dispatching or dispersing the funds directly to the client, maybe we can request that client provides supporting documentation for procurement of whatever it is the purpose of the funds is. And then against that, we would make the payment just to satisfy ourselves that the funding has indeed gone to the supply of that, the supplies that the customer or the client needs, to the extent that it doesn't interfere operationally with the client's day-to-day activities. But I think because we were financing specific assets, maybe what we can consider going forward is paying directly or on the back of an invoice, which we can then trace such payment with once the payment has been made.
Just a follow-up question from the judge here. Does PMV monitor CSI funds, from the PIC? Because there was that 5 million which was given out.
Commissioner, PMV does not monitor any of the specific PIC corporate matters. So if there are any CSI projects which are linked to an investment that has been funded, that part of the CIC is not monitored by PMC. It's considered the PIC corporates matters, and we deal with only the investment-related aspects.
Yes, Ms.
Matsikanda.
Thank you so much for your time, and thank you so much for the evidence that you have placed before us. We really appreciate that. But again, whether this is it for you, you might be called again to come back and enlighten us on some aspect. We don't know, but for now, thank you very much.
Thank you, Commissioner.
Okay.
Commissioner, I just wanted to provide some clarification on the pretty low issue. She was on the 5 million CSI one and not the 21 million MST one.
That's fine. We shouldn't debate it.
Commissioner, at this point in time, I'm told by Mr. Mohapi, my colleague, that he's ready with the next witness.
I think there was a request that Mr. Raja comes back for a few minutes. We can take a 5-minute break for that, just to arrange the chairs again.
Your wish is my command. You can sit down. Yeah. You can sit here. Yeah, no, you can sit. There's no problem. Sit here. Hey?
I can sit here, you can sit here.
Oh.
But that's her chair.
Oh, that's her chair. Okay. Yeah.
Mr. Raja, just to remind you, you're still under oath?
Yes.
Thanks very much, and sorry to call you back. I hope you hadn't gone and come back, but be that as it may. I think what we would like to do is, because obviously what we've been looking at and the evidence presented so far has been about MST. But that was not the reason originally that this matter came to the attention of the Commission and formed part of its terms of reference. That was related to the James Norgu emails and allegations about relationships with the Ms. Pretty Low. And therefore the issue that we need to perhaps look at is what actually happened in relation to Ms. Pretty Low. So if I could start with that, Mr. Raja. I want to come back to the minute in June 2016, which I asked earlier that the MST should improve its BE level through incorporating a female BE group in the shareholding and a female at operational level, right? And to ask if you can just confirm when this airport meeting took place between the Minister, Ms. Pretty Low, and the CEO, Mr. Matjila. I think it was around April of the same year, 2016, is that correct? Does anybody know?
Commissioner, I actually don't know when that meeting took place. In fact, I was told to look at the date, but I was thinking about another meeting at the airport, which I attended, but with Mr. Fernando. That's a different question. Yeah, but on when Dr. Matjila met at this thing, I wouldn't know the date.
Perhaps our legal team could just see if we can find out, or if we know anything about that, because it matters in relation to this resolution. If we take the further information, if we go to the Budlander report, because the Budlander report says, I just want to see what the Budlander report talks of the meeting but doesn't give the date that I could see. And I just want to get to the right position in the document here. And I will just put it into the record from the Budlander report. Ms. Low is not a shareholder or director or employee of MST, but she did have a commercial and financial relationship from which she derived financial benefit. They run a company called Maison Holdings, and I'm not reading it exactly, which is a vehicle for a number of current or intended businesses. And MST, Maison Holdings was introduced to MST by Mr. Wiseman Kumalo when he was seeking a partner for submitting a tender to the KwaZulu-Natal Education Department. And in April 2016 was the first meeting with MST in that regard. They entered into, in July 2016, so after the June meeting about improve your BE credentials, they entered into a formal joint venture agreement with MST, which was termed a consultancy and joint venture agreement. It provided inter alia for the following. MST is the owner of mobile units which seek to supply various government departments in South Africa. MST was approached by Maison with a proposal of sourcing clients on behalf of MST in order to supply mobile units to them. They had identified a number of potential clients to supply the mobile units and has the experience and skills to facilitate a sale and supply of mobile units to various clients. MST engaged the services of Maison to procure suitable clients, and Maison would also be responsible for the business development and account management of the projects brought on by them. So they were appointed as consultant and facilitator, with the primary objective of Maison will be to facilitate, negotiate, and procure the conclusion of an agreement in terms of which the client will either purchase or rent the mobile units from MST. For this, they'll be paid a facilitation fee. And this is an important question. In April 2017, MST paid Maison Holdings 438,000 Rand plus VAT for work done to date, and this is the reason stated in an email from MST to the PIC. So the question being asked is that the payment was made to look at improving BE status and motivate and stimulate our partnership to create further sales. And what I'm asking you is this set up with MST Maison Holdings, introduction by a minister through the CEO, related to the recommendation that this requires an improvement in your BE status and a female operational contract, because then there's something else going on here that does not look very good. Ms. Lowe undertook to provide a copy of the invoice, which was never shown to the Butlander Commission, and in the MST ledger it is reflected as consulting fees, but it is a joint venture. Now you then follow that with a CSI of 5 million, which was related to Ms. Pretty Low, as far as I understood the initial discussions, and a 21 million rand facilitation, loan to MST. Can you let us know exactly what you understand was going on here? Because this does not sit very comfortably.
Through you, Commissioner. Thank you. I'm aware of the agreement. I think it was myself who had submitted that agreement to the Butlander inquiry. If I can start with
Sorry, which agreement are you talking about?
There's an agreement between Mason and MST, which Ms. Marcus is reading a lot of the information from.
And you say you made it available to the Butlander
Yes, I had made it available. If I can start, as I understand it, and I don't have the dates of it, but I think the date of the agreement might have been around when the 21 million or predated. I'm not quite sure. But what I can say is that we were aware of when the only time that we became aware of that agreement is when the publicity started. Then we started asking for this kind of information. And at the time, what I was made aware of by the CEO of MST was that Maison Holdings had been assisting MST in introducing them to various clients. Now, off the top of my head, I remember them saying Department of Economic Development in KwaZulu-Natal, Road Accident Fund is the two names that come to mind. So, but there was no conclusion of any transaction. They had introduced them, but it never resulted in any benefit. So, as I mentioned earlier in my testimony...
Sorry, just to be clear on that, because the agreement was in July 2016 between MST and Maison, but just to be clear, what you're saying is that although they introduced them to a number of entities, Road Accident Fund and others, there was no business outcome concluded from that. It was an introduction and that was it.
Yes, there was no... there was
no realization of a deal.
That's it. That's true. There was no realization of a deal. Now, if we take, so when when I had first met with Ms. Pretty Low, it would have been shortly after the conclusion of the, as you'll know, the first time there was an approval of 30 million rand, but that was not accepted by the client. Then the second time there was an approval on the 8th of June. That was the final approval, and I think disbursements happened on the 6th of July. So I think probably about a month or two thereafter is when I had met Ms. Pretty Low at the PIC office. And at that meeting, she had been discussing the issue about doing some joint venture with MST. There was a bit of confusion in the meeting because I thought, but why is she coming to the meeting now when we had already concluded the transaction? So we were talking at cross purposes. She was referring to a CSI discussion, which I was never part of, but then eventually I figured that she was talking about a CSI initiative. And I had mentioned in that meeting that the CSI initiative does not fall within my domain. That falls within the domain in the finance, in the CFO office. So that was the discussion there. Subsequently, we were furnished with a proposal of funding between 23 million rand and 37 million rand on CSI, making a commitment over a 3 to 5 year period. Now, because my team had already worked on this project, my team took that proposal and went to EXCO. Because it's a corporate decision, it wouldn't go to PMC, and the EXCO was not comfortable with that. They felt that they liked the project, but felt that the amount was too much. And at that meeting, the general manager of finance was instructed to go and look at what budget was available, so that could be committed. And then what I had undertook is that given if there was a budget, I could look into other investee companies in terms of their spend or their BBBE to augment that contribution. So I think it was around about in January or February the following year that at EXCO it was decided, let's commit an amount of 5 million rand. And that was in anticipation of the 31 March year end coming and PIC also having to contribute to CSI. So that was how then that 5 million was dealt with directly with MST. So their proposal of the 23 to 37 million rand involving a joint venture with Mason, that was dispensed with. We didn't agree to that. Now subsequently, when more of these media articles were coming out and we were getting queries, one of the questions asked was, did Mason receive any fee? And that is when I had sent, I don't know whether I had sent an email or I had spoken to Mr. Fernando about the amount, and then he told me, then they sent me an email saying it was 438,000 rand. Now I think that if we say the 438,000, I don't think it would be on a consulting fee, but if you add VAT to it, you'll see that amount is going to come to exactly 500,000, right? Right? So one could also say 500,000 rand is 10% of 5 million rand. Right? So that's the only thing I can't say with certainty, but the amount rounds to 500,000, it amounts to 10%. That's the only thing I can deduce from it.
I could just try to go back to the timelines a little bit because it's a question that Ms. Lowe's, according to the Butlander report, and I'm going with that, Ms. Lowe's first contact with Dr. Matjila and the PIC was on the 4th of April 2016. At that stage, Ms. Lowe had no connection with MST. Her first contact with MST was on about 22nd of April 2016. And from there onwards, then we get into all the PIC's decision-making processes, and MST sends Ms. Lowe a proposal for the PIC on the bus issues, and then there is a request for the CSI funding. And on the 9th of June, Dr. Matjila sends a message to you with a comment for the 5 million, please assist. And therefore, the connection relates back to that, in my mind, the connection relates back to that meeting at the airport. So if this is the outcome of it, then what other influence in relation to business with the minister or business with government relates to Maison? And that is the purpose of the MST Maison joint venture. So my concern here is there seems to be a process by which there's a meeting, there's a request, there's a connection made to MST, there's a CSI, you pay the CSI 5 million and there's a fee paid for services rendered, which the PIC is notified on, that this is the fee paid. It does call into question the decision making. And I accept you may not have been part of all of that, but it does raise questions about process and the way the decisions are taken for me.
Through you, Commissioner, all I can say is that through various stages of the transactions we had done, as far as we were concerned, we had followed process, we are unaware of things until the media coverage was coming out. Then we had to go back and try and look at things. But as we had done the transactions, it was just in the normal, ordinary course of business, and we never, let's put it this way, I mean, it was just like any other transaction.
Accepting. You see, my concern comes back to the minutes of that meeting. If you create an expectation or an assumption that in order to qualify for a PIC in a legitimate manner, a properly invest, this is a good business, we are coming to the PIC for funding, and the concern expressed by the committee is, the committee emphasized that MST should improve its BE level through incorporating a female BE group in the shareholding and a female at operational level. Are you not creating the circumstances in which this kind of activity is inevitable?
I take the point, Ms. Marcus.
But as far as you're concerned, you don't know of any amount. This 480,000 that we are talking about did not come from the PIC, as far as you're concerned.
As far as I'm concerned, it didn't come from PIC, and it is MSTU actually confirmed that they had paid the 438,000 and excluding that to Mason. So they have confirmed that.
But why would they have confirmed to the PIC if it was a joint venture between them, if it was not relevant to the PIC in relation either to the minute or to something else? Why would they have put it in a letter to you that they've paid a consultant fee?
I think there was a question raised, I'm not sure whether it was from the media, but there was a question that was raised as to whether any fees were paid. So I merely requested it from MST, did you pay any fees? And they confirmed that they did.
And do we know if this was the only fee? Or is this the only fee that was recorded at the time that you had? Because again, if it was the only fee, then there's another question. Because then the question of a joint venture and ongoing activity in relation to that comes in.
To the best of my knowledge, I only know of that fee that was paid. That is what MST had communicated to me.
And what would they have paid it for? Was it in respect of the 21 million or something else?
As I say, I'm not 100% sure, but I was trying to deduce that if we take 438,000 Rand excluding that, and if you add on that, it would come to 500,000. So the only thing that I could think of, I mean, if I'm looking at it, is that 500,000 Rand is 10% of 5 million Rand, which is a CSI. That's the only connection that I could make. However, I must add that the CEO of MST had told me that the amount that was paid was not in relation to anything specific, but rather because of the overall effort that Maison Holdings had put in introducing them to various things. That is what he told me.
But if I go back to paragraph 36 of the Budlander report, and to read it in full, on the 1st of April 2017, MST paid Maison Holdings the 438,000 plus VAT, quote, for work done to date. That's the reason stated in an email from MS to the PIC, and it continues. The email also stated that, it goes back to the question of the minute. The payment, quoting, the payment was made to look at improving BEE status and motivate and stimulate our partnership to create further sales. So the interpretation has to be that this was something that came out of that, the PIC approach, from that response from MST to the PIC, and that's the reason why you got the letter. and that's April 2017.
Just to ask a question as she is busy there, if you can sort of remind us, what was the CSI projects for? Just if you can sort of remind us about that.
Chair, I think the CSI was on the education buses.
What was it, sorry? Come again.
Maths and science. On the maths and science
Buses also?
buses, yeah.
Was it a bus? Was it buses? Okay. Then the next one, in terms of timelines, you are saying that you got the transaction from Ms. More, and then we got the other story about the airport meeting. Which is which? Which, who actually gave you to look at the transaction? Which came first and which is which? I'm confused,
The first transaction relates to the 21 million rand loan. That was a transaction that Ms. Mora had met somebody who she didn't mention to me at the time. And thereafter, on the 2nd of July, she had sent through, the client had sent through the documents through to her, and she had forwarded it through to me. So that related to the 21 million rand loan.
Yes.
Well, okay, the initial application was 45 million, culminating eventually in a 21 million rand loan. So that, so that related to that loan. Sure, maybe about 2 months or so after the conclusion of that transaction, when I mean conclusion, I mean in terms of disbursement. Thereafter, we had between 23 million rand and 37 million rand request for a joint venture between Maison Holdings and MST coming to us, and that request is from a CSI perspective, not from client funds. But ultimately, we didn't fund that. We had given CSI funds directly to MST to the amount of 5 million rand.
Just in terms of the date, so the Ms. More's sort of note came before the airport meeting or after that? I just want to sort of clarity on that one. Do you know? Can you remember? Oh.
I think Ms. Marcus gave a date somewhere in April 2016, I think, as
So
the
it came
airport meeting.
before it, yeah?
So this would have been, the 21 million would have been before that.
Yeah. Okay. All right. Just the one thing to follow up on then is that, given that there are some issues about how transactions come to the PIC in general, it looks like, do you think amongst our recommendations we should include the fact that, people must note strictly and in writing how they got transactions and why and those kind of issues?
Through your Commissioner, I would agree to that where transactions come through, perhaps it must always be disclosed the source of the transaction. How did it come to the PIC? I think that would be a recommendation.
It seems that's it, Mr. Raja. Thank you once again.
Thank you.
I'm not going to say you must stay here, not go, in case they want you back again. But thank you so much.
Thank you, Chair. In 2 days, I've been here 4 times.
No, I think for today, I must say you're excused.
Thank you, Commissioner. I think we can take the lunch adjournment if it suits you.
I didn't realize that it was 1 o'clock already. I think we might have been enjoying the session. Yes, we'll adjourn until 2 o'clock.